Okay, so you caught me on a Sunday afternoon. I'm in my backyard, as you can tell, and we're going to talk a little bit about a interesting issue in the Washington Constitution on court systems and our elected court systems, and one of the ways that it is being circumvented right now through an issue called venue. And venue is basically where a case gets tried or which court gets to hear it. And in Washington, we'll do a quick introduction. I've got interviews of these gentlemen from the Silent Majority Foundation who have been challenging some of the statutes and challenging some of the actions of Governor Inslee and helping flesh out some constitutional issues in our system. And they've been hitting this problem of venue, which our Attorney General likes to play with quite a bit. So from that standpoint, let me give you a quick introduction to venue, and then we're going to bring in these gentlemen. This was recorded a bit ago, but I figured I wanted to do a quick introduction on venue before we get into that. So in Washington, we have numerous different counties. And I'm over here in Spokane. These gentlemen were down in Franklin and Benton, which share a court system. And then there's a county called Thurston. Many of you will know it. It is Olympia. And we have a statute that says actions to be tried in the county where it arose. And if you're naming a public officer and it's according to their official duties that they did the action, then you have to go to that county. And what's been happening is our Attorney General has been dragging just about everything he can into Thurston County. Here's the problem with that. The only one who gets to elect Thurston County judges are the people from Thurston County. And so if Thurston County judges who are elected by Thurston County are getting to decide the constitutionality of much of the actions of our government, then you have these voters over here in Thurston County who get a large say, a much larger say in the judges who are going to decide the constitutionality of much of what we do. And it's because of this statute. So if you bring a case here in Spokane, they're going to talk about one that was brought in Grant that then recently just got ordered to get moved over to Thurston County. What that means is even though the people who are impacted are out of Grant County, the judge that they elected and the judges that they elected don't get a say in the constitutionality. Instead, it will start in the Superior Court in Thurston County with those voters. They're going to talk about one up in Stevens. They had this happen for cases they had in Franklin and Benton. And so what this is meaning, and remember, the first piece of our Constitution is all the power is inherent in the people. We have an elected piece, and we'll talk about it in just a moment, but we have an elected piece of judges that are really going down here in Thurston County. And they are getting much more say on the constitutionality and the legality of many of the decisions of our government than any of these other elected people inside the counties. And do not take this as, everyone's unique. Every Superior Court officer is an officer for all of Washington. You just get to elect the ones in your own county or whoever's going to sit in your county. As a matter of fact, there is a case that says there's so much a state officer that, you don't have to elect a judge actually from your county, but you only get to elect the Superior Court judges inside your county. So that's one of the issues that we'll be talking about. The other issue that arises is how that rolls then through to the divisions of our appellate court. So what happens is after it goes to the Superior Court, oftentimes it gets appealed up to the Court of Appeals. And Thurston County falls underneath Division 2. What's happening is the judges, who again are elected out of Division 2 and this area, get much more say on the constitutional issues before it goes in front of the Supreme Court, if it ever does. And the real problem with that is not just the election issue, but one of the things is our Supreme Court has said, and this is important, they count on and they say actually rigorous debate among the appellate divisions is to create and develop the best of Washington common law. So we want debate of cases arising in Division 3, Division 1, Division 2, and what that creates is a wonderful debate and decisions that by the time it makes it up to the Supreme Court, even if they're conflicting with each other, we know we got something the Supreme Court needs to deal with. And we find this out of the case of matter of Arnold, where our Supreme Court came out and said, hey, listen, we want this rigorous debate, even if it creates conflicting law. What it does is it's creating common law. It's creating a wonderful amount of thought and process that comes from all over Washington before it rolls up into our Supreme Court. But unfortunately, on these government actions, what's happening is we're sticking it all in Division 2, and we're not getting a debate out of Division 3 and Division 1. It's not happening because our Attorney General keeps moving it out of here, using that statute to move it over here. And it runs into some fundamental principles of our Constitution that we have problems with. And no one's challenged the constitutionality of the statute. Honestly, it's probably best dealt with by our legislature, but it does create an issue of we the people. And so it runs into Section 1, justice in all cases shall be administered. In all cases shall be administered openly and without unnecessary delay. You'll hear about how this is delaying a lot of decisions. It is not open because many of us don't know the Thurston County judges when we go over there, and we do have a right to affidavit a Superior Court judge. You don't know who you should do that with. That'll come up. Section 32, fundamental principles. Frequent recurrence to fundamental principles is essential to the security of individual right and the perpetuity of the free government. We are not getting the vigorous debate of common law. We'll talk a little bit about that. And Superior Court election of judges. This is where we end up with the problem that, I am in Spokane. We elect the judges in Spokane. They are elected by me and by everyone in Spokane County. But we have no say in the Thurston County judges. And while they may be good, what's happening is they're getting those electors or citizens are getting way too much say in what the law is constitutionally as it relates to some of these very important issues of what the executive branch can do. And then third is the administration and procedure. What's happening is the Attorney General's really trying to facilitate moving everything into Thurston County where he can control it. And that's interfering with this robust debate that our Supreme Court has said it wants among the Court of Appeals. So kind of an end run around. We'll be talking about that as we roll through. Thanks for joining us. This did occur a while ago. I've been learning to edit videos a little bit better. So hopefully you enjoy it. And it is a little geekish, but it's fun. Okay, thanks. Well, I have with me today, I have two gentlemen from the Silent Majority Foundation. I'll have you introduce yourselves.
I'm Rob Waits. I sit on the board of the Silent Majority Foundation. Nothing special about me other than I'm a concerned citizen, father of 6 daughters, and very concerned about their future.
Well, let's say this. What is special about you is you're not a lawyer. And
True.
So
True.
Hopefully you bring some balance to the discussion today as we discuss Washington's Constitution, because it's built for all of us. It's not just built for lawyers.
Absolutely. And I'm Pete Serrano. I am also director of Silent Majority Foundation, and I'm the general counsel, meaning I'm the lead attorney for the organization.
What's happening, one of the things I want to talk to these two gentlemen about is a couple cases of theirs. What's happening is there's a statute that says if you're challenging an officer or a state,
So it's the public officer, and if you're challenging a public officer of the state acting in his or her official capacity, so it has to be, it's a two-pronged inquiry. One, is it a public officer, and two, is it an act done in his or her capacity?
And then you have to go to where they did that act, which for Washington typically ends up in Thurston County. And so I want you, what that does is remember how we started with, we the people of Washington, and this is supposed to be an elected, very people-oriented constitution, yet we have one county, Thurston County, that is getting a lot of the chance to decide the constitutionality of statutes, or I guess more so the constitutionality of an action. And that also means Division 2 of our Court of Appeals, which is supposed to be a unified Court of Appeals, not separate, also gets a disproportionate say. And remember, all those judges are elected now either outside of Thurston County or in the Division II area. So there's a huge portion of our state that is not getting a chance to elect the judges that decide. And
Strictly reality
Mhm.
from my perspective, right, as a non-attorney, Johnson it was all about timing.
Okay,
We all know October 18th, 2021 is gonna live in infamy as the last day all these state employees could work.
right,
And we had to get that TRO before that.
yeah,
All the state had to do to win that case, to push us off, was to get that venue change.
and that's what they did.
And that's
Yep.
exactly what they did, and our case was done. Our plaintiff was out of work and moved on with his life.
Well, and that's so important, and that's what I want to talk about on the Washington Constitution in particular, is this is real people, real lives. This is judges in Franklin County. Was it Franklin or Benton?
It was,
Well,
it's a joint.
Yeah, so it's judges there that this guy who's being impacted has been part of electing. And yet now, boom, it's off to Thurston County to judges he's never heard of. And along the same lines, one of the things that's key in our court system is you have a fair decision maker. And as a matter of fact, our legislatures recognize the fact that we get a right to affidavit one judge. Because of the fact that you get a right to choose a fair decision maker. This guy's not fair. I'm going to someone else now. You can't do it a lot. But if you don't even know the judges in Thurston County, but you know the judges in your local county, how are you going to find that out? And that's one of the problems. We're sending people off, just bam. And it's kind of a trick that AG's doing. That to me, I want to talk real quickly on Johnson. I just read it today.
Yeah.
Again. And I was reading through Johnson, and one of the things it talks about in there was we want to make this, we don't want to subject the chief executive to these decisions of multiple different courts throughout Washington. And I'm reading that, and then I think I may have brought this up earlier. I was reading this other article from Justice Stevens on the Supreme Court, where she wrote this article on regarding Article 1, Section 10 of our Washington Constitution, which is the promise of open justice and access to justice. And she says in there, that's not just a promise for an individual. It's a promise for our community that we want a bunch of cases coming out of multiple different places because it helps us develop the impact on individuals. And by the time they roll up to the Supreme Court, we know this. And it develops the impact and thoughts of judges outside of just one area. We get them from every area. We get the best and brightest of all of Washington. Yet Johnson versus Inslee, exact opposite. They said, no, we don't think. So I partially think that may have still, I would still argue that may have violated Article 1, Section 10, at least the spirit of it. So,
Yes.
You know, one of the interesting things, and I was just reflecting back to our Declaration of Independence, one of the things they complain about King George is he hauls us away to get tried in courts that are not our own. I hate referring back to that kind of stuff all the time but that's true. There's something about us that we get hauled away. And to me, growing up here in Eastern Washington, there is a disrespect that's felt towards Eastern Washington, in my view.
Absolutely.
And Bob Ferguson is like, let me pull you over to Thurston because I don't want to hear from your judges in Eastern Washington.
Right.
And okay, that's
that's
where
I think you're absolutely right, and I can understand where you don't want to go very far with that professionally, right?
Well,
But from a citizen's perspective, absolutely, Eastern Washington, we feel that way in Eastern Washington. We feel like, you know, they just dismiss us. Well, that's just the farmland over there that feeds us.
yeah,
But we don't care about them. We're gonna do what we're gonna do over here. We're gonna make law, and we're gonna cede every power and responsibility in the state and take it away from the locals over there because they're just
Right.
yokel rednecks that don't know what the heck's going on.
yeah.
You know, we're just gonna make those decisions for them over here and tell them what's good for them.
We're just gonna make it in Thurston. We'll use our own judges.
I mean,
But the reality of it is, one of our plaintiffs is a arms store is a gun store.
It's an impact on
It's
it.
gonna take 120, two of them, 120 days before
Yeah.
they can start selling the stuff that makes them money.
Well, and
How many businesses can last that long?
here's one of the things. I know there's another case in federal court, and I just want to say
There are two,
there's
one
two.
in the Eastern and Western District.
I'm glad you guys brought this in state court.
Yeah.
Because I'm all into the Washington Constitution. And only the Washington State Court should be deciding our Constitution. And we do have, I don't want to go into the gun rights one yet. I'm holding off my discussion on gun rights in our Constitution, but we have a stronger constitutional provision for gun rights than the federal one.
Mhm.
And one of the key things in that is you have the right to bear arms for the protection of yourself and your state. There is none of this like militia stuff. It's for the protection of yourself and your state. And I hope our state decides that well. And what a wonderful chance to do that. But now we're stuck fighting Benue in Thurston County.
We haven't even heard the issue.
Yeah.
The issue hasn't even been heard.
And I was gonna tell you, Pete, one of the reasons I wanted to talk about this is actually, I think the solution on the venue issue and the fact that everything's going over to Thurston County and going up to Division 2, and these people get much more voting on our rights than we do. You can abolish that statute. I mean,
So-
get rid of the statute, let the people roll.
So, you know, that was one of the things, probably not surprisingly, we're very friendly with Jim Walsh.
Uh-huh.
And one of the first things I talked to him when we really were full go on, again, as I mentioned, Johnson v. Inslee was our first case. And once we really got our feet up and running, I talked with Jim and I said, listen, man, if you guys can get, because I think it was an even election year at the time, I could be wrong. Or maybe the next year was an election year. I said, if you can get a majority, you got to abolish 4.12, which is the mandatory, as the Supreme Court calls it, the mandatory public officer acting in his public office statute. And I said, Jim, I know this isn't sexy, but I think at the time he was and may still sit on Judiciary Committee. And I said, this is right up your alley, Jim. I can write this for you. You let me know what you want. And Jim was obviously happy to talk about it and look at it and address it. And then, well, we know how the voting went. And I was not about to try to throw that legislation away in a year where, you know, we got the Blake decision, which is drug possession to handle, and gun rights and all sorts of gender ideology, things that the other side of the aisle is clearly pushing. Right. And so I didn't want him to lose that. And so, yeah. And I don't know there's any way to do any type of referendum on that. So,
well, there is, but I mean, the thing is, regardless of what side of the aisle you're on, we are supposed to be a government of we the people. Our rights are supposed to be protected. We should have, at least in the judiciary, the same voice as Thurston County. Our elected judges in Spokane, in Benton and Franklin County, in Grant County should have a say inside what the law of Washington is. Each one is a state officer. It's baffling to me that we don't do that. And it's baffling to me, really frustrating to me that our Attorney General, who's sworn to uphold the Washington Constitution, and just keeps playing that game and ignores that. And I do think it violates Article 1, Section 10. And I'm not sure that, you know, we had a good chance to brief that to the Supreme Court when Johnson versus Inslee went through. I mean,
no, we didn't.
And
I mean, I can tell you that having been on the legal
oh yeah,
with
yeah.
you.
No, I mean, that was pretty much a quick run.
Yeah.
But that's the thing is, and that's the problem with the quick runs, you don't get a chance to brief everything and you don't get a chance to develop it in the court system. And so that's kind of my soapbox. I don't like the fact that our Thurston County is getting so much say.
As Joe voter, I don't feel like I'm represented in the courts at all in Washington.
Really?
I can't be. If everything that matters to me keeps getting thrown over to judges that I didn't vote for.
Yeah.
How am I represented?
Well, and let me ask you this, one of the other things we have a problem with, in Washington, we have the elected judges, which is unique, and, one of the things, there's a justice who I really like on our Washington State Constitution, Justice Utter, who talks about it. He kind of threw out there a thing that, you know, unlike federal judges that are appointed for a lifetime, shouldn't be as, you know, out there innovative, but elected judges could be a little more innovative. I'm not sure if I like that theory, but there is something to it, because you can recall them if they innovate too much, or not recall them. You can't recall a judge, but you can vote them out next session.
Yeah.
And but if they never even come up before us, we don't know them, they're out of Thurston County, we check out.
Mhm.
We have no say, because we can't bring it in our own community, and then I have to travel, and then I'm like, right, and we need to maintain our ability of the power inside the people, because that's what we're built on in this state. We are I hate saying a progressive constitution, but it was a progressive constitution. It was one of these that did not trust power to large corporations or to large government.
Right.
We trusted it back to the people, and we got to make sure it's back there. And I think inside the judiciary, we need to make sure it's back there. And that's one of the things that frustrates me at this whole venue thing. And venue, to our audience, we've talked a little bit about venue, but this is kind of a game that happens. It's a way of putting the ultimate issue on hold, so the judge doesn't have to make a decision. And like Pete said, they can run it up and play this kind of game. And that's a problem. I mean, these are serious issues that we need to develop out. Did they violate the Constitution when they passed that law? Did they violate the Constitution when they passed other laws? These need to be decided. And if you're playing the game on venue like they do, and they want it in their place, because I guarantee you, the Attorney General does know who all those judges are. I mean, not in a bad way. They're not back. I'm not going to say they're back mingling behind scenes, but he knows who they are, and they know who he is. And there's a whole, if he wants to affidavit one, he can, you know, where we don't. I practice, I'd say 95% of my practice is in Spokane, Washington, and Eastern Washington. And so when I go someplace, I have to call friends. What are these judges like? But it shouldn't be happening that way. We should be allowed to develop it in our own community with judges we elected or chose not to know enough about to elect, but people we know. So
Well, there's that sense of accountability, right?
yeah, exactly.
There's no accountability where we're at right now.
Yeah, I mean,
Thurston judge can do whatever he wants to. He's not going to worry about my vote.
yeah, I can't vote him out. He's got no accountability to me, you, to any of us. So that's a real issue. Well, gentlemen, thank you so much. I don't know if you've got more to say on this, but I feel like we've talked a lot.
There's always more to say, but I think we've covered it well. You know, I mean, certainly if you get questions and want to talk about more down the road, we're happy to.
Oh yeah. Well, if we're talking the Constitution today, it's Article 4 in the Superior Courts is what we were talking about. And the election of the judges, they are state officers who belong to all of us, but they're elected per county. And so thank you guys for coming, and thank you both for talking to me and taking your time out. And I do want to point out, they've got to drive back to the Tri-Cities today, so this is a big step. Thanks.
Thank you.